Hey everyone, welcome to our Facebook Live today. My name is Sarah Durham. I'm one of the appellate attorneys here at Blizzard and Zimmerman in Abilene, and we're going to talk about appeals today and maybe a little bit about some writs too, because it does look like some of you have asked questions about writs as well. So we'll just dive right in. Again, we answer the questions in the order that we receive. If you have questions while we're going through this, please put them in the Facebook group and we will respond to those as we receive them. And we'll give you a few minutes to join as well, because I know there were some who told us you have work and you try to jump on when you can. So I'll not start answering questions really for another couple of minutes and give you all a chance to get on if you're able to do that. I guess in the meantime, if any of you, just kind of a Blizzard and Zimmerman recent news, we had a client of ours, one of our writ clients, who was, we won his writ, right? His writ was granted back in December. He was granted a new trial. We had his plea hearing last week, last Thursday in Midland, and he was ordered to time served. So a 75-year sentence became a 20-year sentence, and he is now a free man. So that's actually really good news, and we were really thrilled, especially for our client, but also our firm, as we continue to work toward fighting for people's freedom, and whether it's actual innocence or something that went wrong in the courts or constitutional violations, those are the things that we spend our days working on. So just a little update there. And there is an article in the Midland Reporter. You can see that on our Facebook page, and yeah, we hope you check that out. Make a comment or ask questions there if you'd like. All right, so we're going to go ahead and get started. If you missed part of this, it will be reposted on our Facebook page, so you can catch whatever you missed. And our first question comes from Ms. Plata. She says, courts said the inmate can't appeal. Where or why would the judge base that on? So basically, how do you know if you can even appeal, right? Some people are told they cannot, some people are told that they can, and there is a method to that madness. So if you enter into a plea bargain with the state, let's say the state says, if you plead guilty, we will offer you 5 years probation, and that's it. You say, okay, that's a good deal, I'm going to sign the papers. If you agree to plead guilty and agree to a specific sentence, then you don't have the right to appeal from that decision. So once you sign those papers and once you have your plea hearing, the judge will tell you, you're waiving your right to appeal. You won't get to appeal unless I give you permission to do that, and I, the judge, am probably not going to give you permission to do that. So are you sure you want to plead guilty? If that person says yes, then they have waived their right to appeal and they do not get to appeal. Now that doesn't mean they can't later on down the road assert involuntary plea in a writ, but that has a different standard and different things to consider. But the question, how do you even know if you can appeal? That's it. Like, did you plead guilty? And the court will let you know. So whatever happens at court, the judge will ultimately let you know if you have the right to appeal. So if you plead guilty, he's going to tell you you waived your right to appeal. You don't have that right. If you go through a trial and you were found guilty, the judge will tell you you have the right to appeal. If you can't afford an appellate attorney, one will be appointed to you. And you just have to show that you are indigent or can't afford an attorney. And again, one will be appointed from the appellate will in that county as an attorney to represent you, and they will pursue your appeal for you. Another example of when you can appeal, and it's a little confusing because it's also in the plea context, but it's slightly different in the sense that you can agree to plead guilty, but say, I'm going to plead guilty, but I want to go to the judge for sentencing, or I want to go to the jury for sentencing. So I'm not going to agree to a term of years on probation or in prison, but I will plead guilty. So if you have a sentencing trial, right, you already pled guilty, so all that's left is the sentencing, then you have the right to appeal from the sentencing. You can't appeal your guilty plea, but you can appeal whatever happened at sentencing, and there are just a handful of things that probably or might have, could have gone wrong at sentencing, and then you can challenge that on appeal. Let's see. Not sure who wrote this in, but I think a lot of you and a lot of our clients and a lot of our family members share this sentiment. Someone said, my lawyers sucked. What can I do to get my loved one out of jail? And that is kind of an overarching theme that we see, right? And a lot of emotions run high during trials. Sometimes the lawyers do make mistakes, right? And so that when you're left with, a conviction and you find yourself in prison or your loved one is in prison, it's really easy to feel that way. But you ask the right question, right? What do you do now? What can I do to get them out of jail? And that first step, right, is this direct appeal process where you file that notice of appeal and you argue to the Court of Appeals, things that might have gone wrong at trial. If your direct appeal doesn't work, let's say it goes all the way through the process, you're still denied, your conviction is affirmed, then what do? Right? That's when you can file the 1107 writ of habeas corpus or whatever type of writ it needs to be. And that goes, we've talked about this before, but if you need a little reminding, that is you file an 1107, it's not decided by that Court of Appeals, it's decided by the Court of Criminal Appeals, right? So you get to go up a little higher to the highest criminal court in Texas to decide a writ. Once you get to the end of that journey, it's possible to go into the federal courts. Once you get to the end of that journey, it's possible to even go back to the state courts. And in saying all that, I hope some of you are thinking, wow, that probably takes a really long time, because it does, right? It's not a quick process. It is not a cheap process. But those are the things available to you or available to your loved one if they do find themselves in that position where they've been convicted and they're in prison and they're trying to find out how to combat that conviction. Another good question, great question. What happens if I win an appeal, right? And that's, again, we talk about how to, timelines and what you argue on appeal and what kind of appeals and writs you can file, but we don't, as often talk about, well, what happens if you win? And unfortunately, because winning, it doesn't happen that often, but just like we were talking about earlier, it does happen. 1107s are successful, direct appeals are successful, and you don't know until you try, and that's really, that's what those are the options you have in post-conviction, so you got to try. And if you win, it's a kind of a twofold answer, right? If you win on direct appeal, it depends on what grounds you won on, right? If your issue was sufficiency of the evidence, right? You say, hey, there wasn't even enough evidence to convict me. So, and if the court believes that, then and agrees with you, then you receive an acquittal, which means that the verdict is overturned and you're released. If you win on a ground where you ask for a new trial, if the appeal is granted on the basis of that ground, then you receive a new trial. You go back as if you had just been indicted, right? And you're eligible for a pretrial bond at that point, and then you have another trial. Now, whether you have another whole jury trial or you negotiate with the state in another plea bargain or a plea bargain was really up to you and your attorney, and of course the state and what they're willing to entertain. So if you win an appeal, you're either acquitted or you get a new trial, depending on what remedy you asked for and what remedy the court agrees with. And that's really the same with writs too, right? If you win a writ based on actual innocence, then you are released, right? No holds barred. You are done. If you win on ineffective assistance of counsel and you asked for a new trial, then you get a new trial. So those are your two main remedies there: an acquittal, where you're released, or a new trial and you try it again. Someone asks, how hard is it to actually do an appeal? I will answer that kind of from two perspectives, right? From the perspective of the one incarcerated, it's difficult in that it takes a lot of time, right? It is so slow. I just spoke with a client yesterday, or a potential client, kind of talking about the appeal process and how long it would take. He was recently convicted, and I said, well, now you have this, you're in the appeal process, like you're in it. The notice has been filed, the brief is due. I was like, but, attorneys can ask for extensions. the defense attorney can ask for extensions before they file the brief. The state can ask for extensions. Then it has to go to the Court of Appeals, right? The court has to make its decision. They have to meet about the case. They conference about the case. They have to write the opinion. And so you're looking at it, from between usually 6 months to a year and a half. So I told him, more than likely you're not going to get a decision on your case until the end, the fall or winter of next year of 2026. And that was kind of, devastating. It was devastating news because people just, you don't go and, you don't live your life planning to be convicted of a crime, much less have to be faced with the appeal process. And so it's shocking to some people how long it does take. So from that perspective, it's really difficult for those who are incarcerated, for their families. From the attorney perspective, a direct appeal is, of course it's difficult, right? There's legal analysis and review, and some records are really complicated and the facts are complicated. But compared to a writ, it's a little simpler because it's based on the transcripts, right? An appeal, you argue what happens at trial, and that's it. A writ, you can basically treat it as a new investigation. You can call witnesses, you can introduce new evidence, things like that. So it's more complex in the writ arena. So I would say, that's more difficult, whereas direct appeal, more straightforward and easier from an attorney's perspective. Someone asks, what proof do I need? I'm assuming, and correct me if I'm wrong, if this is your question out there, that you're talking about appeals. And proof is not, you don't need proof in an appeal, because like I said, anything that I can argue as an appellate attorney comes from that transcript or that clerk's record, the things that were filed into the case by both sides. So I'm not looking for extraneous information. I can't even introduce extraneous information because the court will only entertain arguments that are based on what happened at trial. So you don't need proof in an appeal. You need an attorney that is, thorough and reviews the record, front to back, and argues what can be argued on appeal. Now, in a writ, it's a more difficult question because, like I said, if you're trying to prove actual innocence and there's been some new evidence that's come forth, whether it's a victim recantation or DNA evidence or something like that, then that is considered, proof. But the way you have to present it and get it in front of the court and get back into court, it can be pretty complex. So on direct appeals, you don't need proof, right? You just need an attorney to argue the issues. In a writ, you might need some proof, right? Depending on what kind of grounds that you're going to argue. Someone asks, do I got to pay for a writ? Simple answer, yes, right? Writs, and they're typically pretty expensive. There are attorneys across the state who do writ work. We're one of those firms, obviously, and we have to pay for them. They are complex. They take a lot of time. You're looking at, for one attorney, maybe, depending on the complexity of the case, anywhere from like 100 to 200 hours spent in the review, investigation, writing, preparation, and then once you file, there's a lot of things that happen after that the attorney has to stay on top of. So you do have to pay for a writ. Every now and then, a client or a defendant will convince a judge to appoint a writ attorney. That has happened. We've actually been appointed on writs before, but usually the state's going to make a stink about that because technically it's not really allowed. I guess it's however it's argued, right? If the judge wants to appoint a writ attorney, they can, but it does not happen very often. Otherwise, you're going to have to pay for it. Let's see. I'm seeing if I thought I skipped one. Someone gave a really broad question of how does all this stuff work? And I'm hoping, right, that going through these questions one by one, you're kind of getting a sense of how all of this stuff works. And we have a question from Kay Black. She says, I'm trying to prove ineffective counsel. How can I get the information needed? Whew, that's a tough one. So, and those of you who have listened to our videos or check out our Facebook on any type of regular basis, know that ineffective assistance of counsel is one of the main arguments you bring in an 1107 writ, or an 1107-2 or 1109, whatever kind of writ it is that you're filing. And because it's a constitutional violation, right? You are guaranteed effective counsel by the Sixth Amendment, and if you are not provided effective assistance of counsel, then you can argue that that right was violated and you're entitled to relief. So, but to prove that, right, that's the difficult part. And I will tell you, we talked about the two prongs of Strickland, right? You have to prove that, yes, your attorney made a big mistake. That's usually the easy part. The second part, you have to show that that mistake harmed you in some way or harmed your loved one in some way. That's the hard part. Because mistakes are made all the time, right? Attorneys are humans, they make mistakes. Now, whether those mistakes really harmed and impacted, and negatively impacted a person's case is the question. So the information that you need to gather, that you asked about, would be first and foremost the trial counsel's perspective, right? Because you cannot go to a court and say the counsel was ineffective and not provide that counsel's side of the story. Which is why, kind of taking that back to direct appeals and writs just for a minute, ineffective assistance is usually never, ever, ever successful in a direct appeal, because the appeals court says, I mean, this isn't really the place to argue this because we don't know what the attorney was thinking. Like, we don't know if they can justify what it seems like they did or didn't do, or, you know, if it really is an error that we should be considering. So if you don't have the trial counsel's perspective, don't assert ineffective assistance of counsel. Now, how do you do that, right? How do I get that trial counsel's perspective? In the direct appeal process, you can file a motion for a new trial, right? If you know there's ineffective assistance or you think there was, file a motion for a new trial, assert ineffective assistance. You'll have a new trial hearing, and at that hearing, the trial counsel can be questioned, right? And in that questioning, right, about what they did or didn't do, you're expanding the record, right? You're making it, you're putting on the record that you can use on your appeal the answers from that trial counsel. So then when you argue ineffective assistance on direct appeal, you can say, well, at the motion for new trial, he testified or she testified to XYZ, right? Therefore, you know, and that's really, you know, not a justifiable reason for doing what they did or not doing what they didn't do. Here's some case law to back that up, and you can argue ineffective assistance on direct appeal. If no new trial motion was filed and you're just filing it in a writ, you still need that perspective from trial counsel. So typically, once you file the writ, the appellate court, or not the appellate court, I'm sorry, the district court or the convicting court where you first file it will order an affidavit from that trial counsel. So trial counsel will provide an affidavit responding to your allegations, and then be able to either justify, again, his reasons and decisions or not. As far as other things that you might need to show ineffective assistance, I can't really think off the top of my head what that would be. The perspective of trial counsel is number one. And of course, when you're arguing what they did wrong, you just need to explain that well, right? You cite from the record if that's what happened, if they made a mistake on the record, or if they failed to provide mitigating evidence, or if they failed to inform you of everything, all the facts and law surrounding your plea, those kinds of things. And you can also provide an affidavit from the defendant to lay out those things for the court too. But the perspective of trial counsel is of the utmost importance on those kinds of claims. And we have another question. Ms. Boops, which I know that you were on our last Facebook Live, and you returned and said, my son's lawyer hired a PI, and the PI showed him some evidence. Does that count as the lawyer showing the discovery? Yeah, well, I mean, he was shown discovery, right? So yes, he was shown discovery if he understood it. And his lawyer, if he didn't understand it, and he reached out to his lawyer about it and was not, you know, kind of the importance of it or what have you, or his questions weren't answered, maybe that could be a problem. It really depends on what kind of discovery it was and what his questions might have been and if it impacted his case, right? I think best practices would be to review discovery with your client, but a lot of the times, I mean, discovery can be very voluminous, right? And so as the attorney, you review it to make sure there's nothing crazy, maybe nothing missing, but then when it's time for your client to come in and review it, maybe you leave them, somewhere to review it. If they have questions, come ask me and we'll talk about it kind of on a global level, before trial, definitely, and talking about defense strategy. But not explaining isn't in and of itself ineffective assistance. You would definitely have to tie it to some harm, like we were just talking about. Ms. Boops also asks, says, a letter was written to my son's lawyer for his lack of help and requested to fix his negligence. I'm afraid the lawyer will not give me his notes on the case, or he will change, add, or omit things. Is that possible? And if so, what does that mean for us? So when you ask for your defense file, the client or the trial counsel should give it to your son, right? Because that is his file, it belongs to him, with a really, really important caveat. The discovery, like if there is discovery from the state in your son's file, then that cannot be shared. It cannot be emailed, it cannot be mailed. Discovery cannot be transferred to another person. It has to be viewed, with the attorney or in the attorney's office with staff, by the defense or by the defendant. Nowhere in the process can an attorney provide the client with copies of discovery, and that's just pursuant to 3914, which is one of the articles in the Code of Criminal Procedure. And if you've asked your attorney for a file, I guarantee you they probably mentioned that number to you, and they're not trying to dodge a duty or anything like that. They're really just trying to follow the law and not get into trouble and say, okay, I can give you these things, right? These things like my notes, maybe public records, things like that. But as far as what the state gave me in discovery, I cannot share that. To view that, the best thing to do would really be to hire a writ attorney. They could view the discovery and then share what they learned with the defendant, or review it with the defendant as well, just like a trial counsel would. Another question, can you be indicted on a jail phone call? Lawyer said the prosecutor will do so if he does not sign the plea deal. Can you be indicted on a jail phone call? I think, I mean, really that depends, right? So jail phone calls with attorneys are not supposed to be recorded, right? So I'm assuming you're talking about a call with a family member or friend or something where the lines are recorded. If they admit to any wrongdoing, that could be used against them. I don't know that that would produce a brand new indictment, but it could lead to new charges for sure. And for the state to look into those, right? Start questioning about those things, and take it to a grand jury, right? So you could implicate yourself or incriminate yourself in jail calls, certainly. That's why we tell our clients, do not discuss your case with family members, with friends on jail calls or in JPAYs or, any of the messaging things that go back and forth between the jails, because those are monitored. I mean, they really are. We've had jail calls played at trial, right, in front of the jury. So definitely advise, and again, your attorney probably already advised you to do that, but as family members and friends, just don't engage, right? Don't engage your loved ones in conversations about the case, because it could be detrimental to them in the future, or detrimental to their case, for sure. Okay, let's see, we've got another one from Miss April Hernandez. She said, my husband was coerced into a plea. The attorney wasn't ready for trial. Victim didn't want anything to do with the case, and there was no impact statement. Yeah, so that happens a lot. So I'm going to take it the first part, right? If he was coerced into a plea, We all know that if it was a complete plea bargain where he pled guilty and agreed to a sentence, he has no right to appeal, right? So he cannot appeal that decision. But you're saying he was coerced, therefore it wasn't voluntary. And so that can be challenged in an 1107 writ of habeas corpus as involuntary plea. Now, involuntary plea is usually tied to ineffective assistance of counsel, right? It doesn't have to be, but that's usually the way it's presented. And so if counsel didn't, investigate or didn't tell your loved one about a certain fact or something that was known in the case that would have impacted his decision whether to plead guilty or go to trial, you can assert involuntary plea. Now, if the victim, I think you said the victim recanted, or said that they wouldn't testify, and that happens sometimes, like in assault family violence cases, where you have someone even sign an affidavit of non-prosecution and they don't want to testify. They want to drop the whole thing, and the state's like, well, too late, too bad. You've already made a statement. We already have enough evidence against this client. Therefore, we're going to move forward. So you either plead guilty or we go to trial on whatever this is. That is, that happens all the time. Now, if you have a victim that recanted and it's some kind of sexual assault or something that can be proven that didn't happen, that could be worth filing an 1107 and asserting involuntary plea. It really just depends on the facts of the case, and so I can't give you just a determinative, definitive, like this is exactly what you should do. But it sounds like that would be your option, right? Involuntary plea via 1107 writ of habeas corpus. I hope, did I miss the end of that? I thought there was another piece to that question. I'm sure that I did miss it. Yeah, no, that's fine. Okay, someone says, if a charge was dropped, can the prosecutor, if a charge was dropped, can the prosecutor bring it back up along with a separate charge? The prosecutor said he will add if he goes to court. So charges can be added, right? But they have to, so you have an indictment, right? And you've been indicted on, and I might be going a little further into the case than where it is now. I mean, as far as what I'm going to charge you with, yes, they can add more things, right? Until the cows come home, right? So I'm going to charge you with theft, and I'm going to charge you with, burglary, and I'm going to charge you with, whatever it is, whatever the facts of the case lend themselves to. But once they go to the grand jury, right, and get an indictment, and you've been indicted for, aggravated assault with a deadly weapon, right, and then you're approaching trial, and they try to add something, a new charge to that indictment because, you won't plead guilty maybe, right? So they're like, well, if you don't plead guilty, we're going to add, this, which we could have added in the first place, but we didn't, and so we're going to add it now. Well, that's considered, they can't just add that to the indictment, right? That's considered amending the indictment. You can't do that over the defendant's objections. It has to go back to the grand jury. So any charge that's indicted means that it has gone in front of the grand jury. They have said, yes, there's enough evidence to make us think that this crime was committed by this person, and so we're going to true bill it, which means we're going to, basically give our okay that this thing goes to trial. So every charge has to go through that process to be able to be on an indictment. So if things are just added to the indictment over the objection of defendant, that can be challenged on direct appeal. We've been successful at those actually, and we had convictions reversed for that very reason. You can't just come in here and say, well, we want to add this or we want to add that. It's like, no, you go back and you take it to the grand jury, or the defendant agrees, okay, I know it's going to end up in an indictment. I don't need 10 extra days to prepare, and I'm not going to object to it. You can do that. But if the defendant does not agree to those amendments or those changes or those extra charges, then you can challenge that on direct appeal. Again, if it didn't go through the grand jury. Let's see. Donna Glaze asks, You said a lawyer can't mail the defendant the discovery. Why not? Why can't defendant go through all of that paperwork without being in possession of the discovery? I mean, I completely agree with you. I've always thought the discovery rules were pretty strict in that sense because, I mean, this is the evidence that the state has against you. And not necessarily, it's not all, inculpatory, meaning it's not all evidence that is going to convict. It's also could be exculpatory evidence, evidence that's going to exonerate or tends to, combat the guilt. So the state, all of that's part of discovery, right? You've got witness interviews, dash cam videos, police videos, all kinds of stuff, right, as part of discovery. I think a lot of the reason for the 3914 restrictions are to protect victims, protect witnesses, because a lot of the times in discovery, right, you have people's, names, their addresses, birth dates, where they live, all this stuff, and that can be very sensitive if you're talking about people who are accusing others of certain crimes and things like that. So, I mean, I understand it to that degree, and really I think that's kind of the spirit of the law, is to protect the communities and victims, and then it's the attorney's job, right, to make sure, knowing that those are the restrictions and knowing that we are the only way our defendants are privy to that discovery, it's our job to say, here's your discovery, right, and I'm going to let you see all of it, and you need to review it, and then we need to talk about it, right? That's an attorney's duty. So that is, and then as far as, like I said, other things that are public record, that are part of the defense file, then those should be given to the defendant, definitely. Can the Texas Board of Criminal Justice help with an 1107? Texas Board of Criminal Justice. I'm not sure. I'm not sure if you're talking about public defenders, or I'm not really sure what that question is asking. Public defenders, I don't know how many 1107s, if they do any 1107s, and then I know that as far as like resources to help with 1107s, there are innocence clinics all over the state. So if you are contemplating or you think that you or your loved one is actually innocent, they all have application processes, and you can reach out to them. All of the law schools have innocence clinics. And what that is that you apply, right, and you have to fill out all this information about your case, and they will review it and see if they want to take that on as a project in that innocence clinic. And so you've got law students and professors who review these cases and end up taking them through. A lot of times there are also attorneys across Texas who are contracted with them or volunteer their time to help with those innocence writs as well. I think there's been, I think TDCJ has, I forget the name of the office, I apologize, it's basically a counsel for the inmates. I've seen them handle or help with writs before, but as far as any kind of like free resource, the actual innocence clinics are really all that's that I know of to prepare and file an 1107. How does the course work for 1107? So Blizzard and Zimmerman, we created a course several years ago, I think it was 2020, where we just created these modules, kind of like a college course that you would see, where we take the different topics that are pertinent to an 1107, whether it be record gathering or the kinds of grounds you can bring, or what does a brief look like. We provide a brief bank with sample briefs and sample applications. The course, if you sign up for it, you go through and you watch those modules, and you'll kind of start getting the feel for it. Like, okay, I don't need to watch the module on prosecutorial misconduct because that really didn't happen in my case. So I really, want to focus on the ineffective assistance module, maybe the involuntary plea module. Anyway, you go and you look at those modules, and basically it's like this, but with the, a script that we came up with, just explaining and teaching people what the writ process consists of and how to navigate it, the best that we knew how to explain for non-attorneys. So there's also built into that an hour strategy session, and those are usually with me. I ask that our course members send me what they're working on. So I get maybe a writ draft or some notes or something like that I review before our strategy call, and then we talk about those things. A lot of the times I'll revise them, edit them, send them back, just as a way to, kind of, because people want to know, am I on the right track? Am I thinking about this the right way? Because these writs can be filed by a family member, by a friend, by the defendant themselves, right? So that's pro se if it's by the defendant themselves, or a family member can just file as the petitioner and just sign it and swear that everything in it is true and file it with the courts, just like an attorney would. It is a difficult process. Those that have taken the course can attest that it's difficult. We've had some that start with the course and end up calling us back and being like, you know what, I'm just going to hire you, right? Let's just hire you and you take it from here because this is too much. So it really depends on the complexity of your case, how much time you have to invest in going through those modules, and how well you soak in that information and then can use it to prepare your own writ. So that is how the course works, and it's at your own pace. If you do have questions throughout it, of course we're very accepting of questions, and Tom Bodak is who you'd get the email from when you first sign up for the course, and he's there for your technical difficulties if you have those. And we really just kind of come together as a team to help those course members who might need help and make it a good experience for everyone. Let's see, we have more questions. Y'all are really on top of it today, asking these questions. What is the difference between a 30-year sentence with eligibility for parole in 25 years and life in prison for an ag robbery charge? The lawyer said he will get life if he doesn't sign the plea. I'm confused. Is his current sentence a life sentence? So he got a 30-year, hold on. He got a 30-year sentence. They said eligibility for parole in 25 years, which is weird. And life for ag robbery. Okay, so a 30-year sentence, I don't know why unless there's like extenuating circumstances or something in the plea that I'm not aware of, a 30-year sentence on an ag robbery, that's an aggravated offense, and so that's what used to be called a 3G offense. You'll still hear them called that, because they at the time were in section 3G of the Code of Criminal Procedure 4212 3G. Now they're in a different section because there's been updates to the Code of Criminal Procedure, and it's 42A.054. Not really that important, but we still call them 3G. So if you hear that term, that means it's an aggravated offense, and that's important because when you're talking about parole eligibility, the defendant will have to serve at least half of that sentence before they're eligible for parole if it's a 3G offense. So on a 30-year sentence, they would have to serve 15 years before they're even eligible for parole. And we all know that eligibility doesn't mean you're getting parole. It just means you come up for your parole review. You can get offset by however many years, right, if you're not granted parole. So maybe the attorney was saying, hey, your chance of getting parole at 15 years is not good, and you might end up serving 25 years. I mean, that's an accurate statement, but just from the get-go, I probably wouldn't think that, right? Ag robbery, serve 15 of the 30. If you got life, so life in prison on a non-capital offense is you have to serve at least 30 years before you're eligible for parole. So you get a life sentence, you're eligible for parole in 30 years. That's just how it works. If it's a capital offense and you get life, you're eligible for parole after 40 years. So that's the difference. But yeah, I'm really not sure. If he got a 30-year sentence, that's not a life sentence, to answer your question. April Hernandez asks, can we sign affidavits stating what we hear in attorneys' offices about pressure to take the deal and what he told them about the victim after he signed the plea deal? You absolutely can. So we have family members, and this is if you file a writ, right? Because we talked about writs. You can bring in that outside stuff, affidavits, evidence, talk to witnesses, do another investigation even if you wanted to. But we have in cases gotten affidavits from family members saying this is what happened in our meeting, right? And just kind of another caveat, like in a writ, you're basically forfeiting or waiving your attorney-client privilege, right? Because you were saying, this is what my attorney told me. Your family members are saying this is what, the attorney said, and so just kind of know that going in. But that's typically not an issue for anyone, right? Because that's what you're trying to say, like, I don't want to hide behind privilege, right? I want people to know what my attorney said or didn't say or did, and that's the whole point of ineffective assistance grounds. So yeah, but to kind of confirm or affirm my answer for your question, you can file affidavits saying what you heard. You just have to make sure you tie that into the overall ground, right? Involuntary plea because he was coerced by, right, this is what was said, this is what was discussed. The family members' affidavits, that's good, but may not be necessary if the defendant himself provides his own affidavit as to what was said. But I mean, it wouldn't hurt, right, to kind of corroborate how things went down. K. Black, with the course, does your firm do a review to see if the case is warranted of an 1107 writ? We do not. We don't do reviews to see if cases are basically, if a writ is going to be a righteous one or not. We do, like our firm and a lot of firms out there do writ investigations to where that's exactly what we do. We get in there and see, we gather all the records, we review it just as if we were going to prepare it as an 1107. Typically, those are writs where people have already filed a writ, and so they're limited to what they can argue. So they'll hire us to do an investigation to see if an 1107 can even be filed. But some people come to us kind of filing their first writ and just want to know, what do I have, right? Do I have grounds? And, we do consults, we do paid consults, and we do talk to people a lot about their cases. Sometimes those consults run an hour long. And we'll talk to the defendant about what happened in their case, what they think went wrong, and kind of make that preliminary decision, like, yeah, you could possibly have, this ground, or this ground, or it sounds like, we need to look more into, this issue or that issue based on what you're telling us. And we have had, people who hire us to do the investigation, and then they go on to hire us to prepare the writ because we found something that we're like, there are no guarantees in writs or in law at all. But we say, we think you have some really strong grounds. We found X, Y, or Z, and we really want to move forward with this. If y'all agree, let's do it. So that does happen quite a bit. Let's see. Does it depend on the nature of the crime to be eligible for probation? Is lack of criminal history and lack of presence at the crime scene a factor? So, hold on, does it depend on the nature of the crime to be eligible for probation? It does. There are some crimes out there not eligible for probation. Your criminal history does dictate that as well, but that's a really complex area of law. I can't go into all the different offenses and things like that, but it's a section of criminal procedure. Lack of presence at the crime scene, I would think lack of presence at the crime scene would speak directly to actual innocence, or some kind of, if you're not there, I don't see how you could have been involved in the crime. So that's kind of that's a whole separate issue. But yeah, there are some crimes that are not eligible for probation. Oh, that's not a question. That's a command. So we spoke earlier, just when we were getting things rolling, about the writ case that we just won here at Blizzard and Zimmerman. And I'll just give you kind of a brief overview of what happened in that case. We linked that, it was in the Midland Reporter, and so we linked that to our Facebook page. You can go there and read more about the details, but I'll give it to you from just our firm's perspective and how the journey that we went through with this family and our client. So they came to us in 2021. It was one of those Midland cases, the Ralph Petty cases. If you've read about that, heard about that, the most famous one being the Clinton Young case, where he got a new trial after it was discovered that one of the ADA prosecutors, Ralph Petty, was acting as both a prosecutor and as a law clerk for the judges working on habeas writs. So, and prosecutors do work on writs, right? But as state prosecutors. Petty was doing both. He was working on the writs, working in the trials, and then working as law clerks for the judge. So basically kind of having the judge's ear, right, on certain aspects of, post-conviction stuff. So like in our case, he did some things at trial, right? Like I think he even argued some objections. And then he actually wrote the writ for the judge, like did a lot of the things that the judge is slated to do, and did that for the judge and got paid separately. So it wasn't him doing his job as a prosecutor, it was doing his job as a prosecutor and a law clerk. And the Court of Criminal Appeals decided, you know what, that's not okay. Like in the Clinton Young case, in our case, two other cases, Lewis and Saeed, they said, the appearance of a judge being unfair, right, is enough. Like you don't even have to show that the judge was actually unfair, that it's enough that the judge was apparently, right, or there was an appearance of impropriety or unfairness. And so because of that, right, our client the writ was granted. But that was after, I mentioned to you earlier about the long process of appeals. They came to us in 2021. The writ, and it was the end of 2021. By the time we were ready to kind of pull the trigger on preparing the writ, it was toward the end of 2023. We filed, and then it was denied. Right? It was extremely disappointing. Right? I had to call my client and say, your writ was denied. We then filed a 2254 in federal court, which is a federal habeas writ, challenging the 1107 decision from the state court. It was denied in 2024. Again, I had to call my client and say, we lost again, right? This is, kind of the end of the road. But my team here at Blizzard and Zimmerman, we are a team, right? It's not just me, it's not just Jacob. We all work together on these things. And one of the members of my team, I think it was Morgan and Yasmin, found a case, right, from, I think it was mid-2024, where the Court of Criminal Appeals had granted relief on the same issue, right, the Ralph Petty issue, but in a way like Ralph Petty even had less to do with that case than he did in our case. So seeing that, we're like, man, I mean, we're just going to have to ask the court to look at this again. So we filed at the end of 2024 a request for reconsideration to the Court of Criminal Appeals, who had already denied our 1107. We were already denied at the federal level. We filed a request for reconsideration, and they granted it. And it was like, hallelujah moment. And we called our client and we said, it's been granted. He was bench warranted back to Midland. And at that point, he's eligible for a pretrial bond again because he's facing those same charges again. So he bonded out, and then last week we had his plea hearing, and the judge ordered him or sentenced him to time served, which was 19 years, 2 months, and 4 days, or 4 months and 2 days. I might be flipping that. And so he was released, and he is a free man as we speak. And he was originally he was serving a 75-year sentence in TDCJ for aggravated assault with a deadly weapon. And he has never said he didn't do it. He has never, well, I guess at his trial. But, I mean, there's different degrees, right? But he, pled guilty, said, yes, I'm guilty of that, was granted time served because of that judicial impropriety that happened at his case. So, you know, it's not just actual innocence that's granted. I mean, these things are granted based on constitutional violations all the time. And April Hernandez says, what might come out of the 1107 if he gets granted any relief from the coerced plea deal? So what might come out of it? So in an involuntary plea context, you are asking for a new trial, because the involuntary plea standard, if you attach it to ineffective assistance, is my lawyer did something wrong, right? He didn't tell me of all the facts. He didn't even tell me that this evidence existed. Had I known that that was true, I would not have pled guilty, but I would have insisted on going to trial, right? So what is the remedy? Go to trial, right? Get a new trial. Now, that doesn't mean you have a new jury trial, right? Maybe it means, like I said earlier, negotiations are reopened with the state. But that would be your remedy, right? Would be the new trial. Now, if the plea was coerced and there was a colorable argument for actual innocence, that's different. So maybe someone pled guilty, but they really weren't guilty. They pled guilty because they were under duress. They were coerced. And if you can prove that, and if you can prove that the plea was involuntary and also that you were actually innocent of the offense, then any time that you have been incarcerated has been a wrongful incarceration. And you can then apply for monetary relief to the Texas Comptroller under the Tim Cole Act. If any of you have heard of that, Tim Cole Act is kind of the vehicle by which people who were wrongfully incarcerated go to the Texas Comptroller. They say, hey, I got an actual innocence finding by the Court of Criminal Appeals. Here's all my paperwork. Here's the time that I spent in prison. And you can then get monetary relief to the tune of like $80,000 a year for each year you were wrongfully incarcerated from the state of Texas. That's happened with one of our clients as well. He spent 5 years in prison. He shouldn't have. We were able to prove actual innocence, and he got the monetary relief from the state of Texas for that. So it depends. Back to your involuntary plea question, on what exactly you're arguing and what relief you're asking for. If you ask for a new trial, that's the relief you get. If you're arguing actual innocence and it's granted based on actual innocence, then you can think about seeking that relief from the state of Texas. And I think that is all the time we have. You guys asked some great questions today. Per usual, they just kept on coming in. That was really good. We will do another one of these in the next month or so, and I look forward to talking with you all again. Remember, if you have questions, you can always email us at appeals@blizzardlawfirm.com, or you can post them to one of our Facebook pages, our BNZ Facebook or BNZ Winning Freedom for the Incarcerated in Texas. And we monitor those all the time, and we'll answer you there. And I think that's about it. So I will see you all next time. Have a great day.